Findings and conclusions. In an act of the legislature, whether parent or amending, there are recitals to explain the state of affairs or mischief which necessitated such enactment or amendment. This is normally not the practice in the case of framing of rules and regulations under it. There is no recital in the impugned rules. In the Act and in the 1965 rules, there is provision for plurality of warehouses. Article 19(6) is clarificatory of Article 19(1) to 5 to the extent that carrying on business by the state in a particular field to the exclusion of private entrepreneurs cannot be taken as unreasonable restriction on the freedom of citizens to carry on trade and business. This in no way prevents the state from engaging a private entrepreneur to do monopoly business in a particular field if the facts and circumstances require. However, this kind of decision has to satisfy the test of reasonableness because by such act, the state is preventing other private entrepreneurs from doing business in a particular field. A monopoly, in our opinion, would refer to exclusive control of an entire industry, business or service at all levels and in all areas of its operation by a particular person to the exclusion of all others. Regulation by the legislature of part of a business by authorizing a person or entity to carry it out more effectively in public interest cannot be called creation of a monopoly of a private person by the legislature or by the state. Amendment of the Meghalaya Rules 1965 by the 220 rules by creation of a central warehouse did not set up a monopoly business but regulated a part of the trade in foreign liquor in the state of Meghalaya. Even if setting up of the central warehouse is treated as setting up of a monopoly business, still the government in the given facts and circumstances of the case was entitled to authorize a private entrepreneur to do monopoly business in the trade under the Assam Act 1910 and the Bonded Rules 1965 framed thereunder as amended from time to time. A plain and ordinary and grammatical and purposeful interpretation of Section 19 of the Assam Act makes it plain that it only refers to the power of the government to channelize the trade in country liquor. In no way does it exclude or restrict its reservoir of powers under the said Act to otherwise regulate the trade, which includes regulate the trade in foreign liquor, which includes creation of the central bonded warehouse, even if it is taken as a decision to permit the central bonded warehouse to do exclusive trading business in part of the trade. The promulgation of the Rules 2020 has to be seen as a policy decision of the government. We have found nothing in this policy which could be termed as unconstitutional or violative of Article 14, 19 or 21 or illegal, arbitrary, unreasonable or perverse. At least from the face of the notification, the businesses of the bonded warehouses is not interfered with. They would only have to buy or procure the liquor from a central bonded warehouse instead of buying it from the open market. The rules contain detailed provision for the stock to be maintained by the central bonded warehouse and the mode and manner in which it has to supply this stock to the bonded warehouse on its demand. The price of a bottle of liquor is fixed by the excise authority. This price is inclusive of all taxes, levies and commissions. The version of the government is that the demanded quantity of liquor of the description and quality ordered by the retailers on the basis of demand by consumers would have to be adhered to by the central bonded warehouse. Creation of the central bonded warehouse removes the likelihood of bonded warehouses in entering into transactions or arrangements which select manufacturers, bottlers, brand owners to trade only in select brand of liquor where the margin of commission is more. Up till date, there is nothing on record to show that any demand for liquor made by consumers and routed through retailers and bonded warehouses has not been fulfilled by the central warehouse. The only legitimate grievance which the writ petitioners have against this piece of subordinate legislation is that to maintain the fixed price, the commission receivable by the bonded warehouses has to be shared with the central bonded warehouse, resulting in diminution of the margin of profit or earning. It has not been shown that the average earning of a bonded warehouse or manufacturers, bottlers and suppliers has fallen after the coming into force of the rules. The affidavit filed by the state in fact shows that the sale of premium foreign liquor has substantially increased since coming into force of the impugned rules. This is very important. This is a particular brand of subordinate legislation which on the face of it is not invalid. However, it is possible for the state to apply or implement this rule unconstitutionally or fail to take action against those who misuse it. In that case, the rule itself becomes a monster and is liable to be struck down by the court both as a piece of illegal and invalid legislation or as a bad policy. If, for example, the central bonded warehouse is used as an engine to throttle the business of other bonded warehouses by the state, allowing a large commission to it and reducing the commission of bonded warehouses, thereby causing a huge diminution in their turnover from business, then the notification becomes a monster or arbitrary or unreasonable, promoting the business of the central bonded warehouse and causing extraordinary loss to the other bonded warehouses. Allowing the central bonded warehouse to favor one bonded warehouse against others or a group against the rest, resulting in detriment to the business of others, would produce the same result. Failing to absorb the extra and unreasonable amount of commission the central bonded warehouse would claim and earn against the taxes received by the state or against the price reasonably, would have the same result. We are really pleased to receive the assurance of learned counsel for the state, Mr. Banerjee, that it was willing to apply and work the rules out according to the guidance and direction given by the court below. So these are the directions. The state government is to strictly monitor the business carried out by the central bonded warehouse with the other bonded warehouses, the manufacturers, distillers and suppliers. By an administrative order, the state shall fix the commission to be charged by the central bonded warehouse. If required, this extra amount of commission is to be first absorbed by the government by reducing its taxes or otherwise on a bottle of liquor and thereafter enhancing the price of a bottle so that the enhancement in price is minimal and does not affect the market demand. It is to ensure that there is no applicable fall, there is no appreciable fall in the percentage of commission earned by the bonded warehouses or the amount realized on account of commission. The government is to closely monitor the activities of the central bonded warehouse in relation to each of the other bonded warehouses so that the stock and description of liquor made available by it to each of the bonded warehouses is more or less the same as it was before the introduction of the impugned rule and in accordance with the demand received from retailers routed through the bonded warehouses. The government should ensure that the central bonded warehouse does not discriminate between the bonded warehouses and carries on its business in a fair and transparent manner. If the government receives any complaint from any interested person with regard to procurement, supply and distribution to the bonded warehouses by the central bonded warehouse, it shall immediately entertain the complaint and take necessary measures to solve the problem. Therefore, as of now, the rules stand, but subject to its application and regulation properly and reasonably by the government in accordance with our observations and directions above. In those circumstances, we declare that the impugned rules are valid and inter vires the Constitution and the laws. In case of infraction of our directions resulting in misuse of the rules, the writ petitioners shall have a fresh cause of action to file a proceeding to declare them as invalid and ultra vires. Both the writ petitions are disposed of, declaring the so-and-so rules as constitutional and valid, but subject to compliance by the respondent state with our directions above for implementation of the said rules. We grant liberty to the petitioners to apply a fresh for quashing of the said rules in case there is disobedience to our directions or failure to implement the rules in accordance with our directions. Miscellaneous applications also stand disposed of.
Grateful minutes. Obliged.
Deep.
Right.
Number 3 to 6.
This may chamber. Yes. No, Assam something rules. Lot of policies will be the best.
Yes.
Yes.
Please, Lord. But so these are almost a mercy petition before Lordship. My Lord, Lordship has passed a judgment, and we are undertaking that we have taken a decision.
The secretary.
Secretary, my Lord.
It was-
My Lord, here what happened was the secretary is a very senior most scientist, my Lord. He was a director of IIT Kanpur, and he is a scientist of fame, my Lord. And certain observations, my Lord, he personally called me. He said, if this some observation could be expunged, my Lord.
Where are
Yes, my
those,
Lord. Otherwise, we are happy with the judgment, my Lord.
where are those observations?
My Lord, at page 34, your Lordship kindly sees, my Lord. At page 34, my Lord, the sixth sentence, it starts with the governing council at the instigation of the secretary.
Page 34.
Yes, my Lord. This is a part of the operative part of the order, my Lord. Same page, no? But the sentence, the governing council at the instigation of the secretary should not have turned around ninth meeting and cancelled the appointment. The purported exercise of power by secretary at its ninth meeting by the government was totally irregular and arbitrary. And then in the next para, my Lord, the second sentence, the final outcome which was reversed had been negative at the whim and caprice of the secretary engineered through the governing council. Nothing could have been more unfortunate. Well, this can be mellowed down also, some with some other words, my Lord.
Secretary is also a member of the governing council.
He's the chairman of the governing council. He's the ex officio chairman, my Lord.
Any other part of the order?
Only these two parts, my Lord.
Just toning it down a little bit.
I'll be obliged.
Mr. Paul is appearing.
My lords, I am there for that.
Just toning it down a little bit. Having heard learned counsel for the parties. And especially the most and especially the most politely persuasive submissions of the learned Deputy Solicitor General. We make the following alteration. In the last two sentences, of the paragraph at page 9 of the judgment and order dated
5/4/24. Sorry, 8/7/25.
8/7/25.
8 July 2025. In the following manner. The said two sentences are deleted and substituted by the following colon next line quotation. The Secretary, as Chairman of the Governing Council, convened its ninth meeting. Full stop. The said council at this meeting cancelled the appointments. Full stop. This exercise of power by the governing council was wrongful and illegal in our opinion. That's all.
My lord, one more sentence, my lord, in the next para, my lord. In the next para, second sentence, the final outcome, which was irreversible, had been negative at the whim and caprice of the secretary, my lord. And this also, my lord. Engineered through the governing council. Nothing could have been more unfortunate.
The next line you write, the first fresh paragraph of page 9 is deleted and substituted by the following. The appointments had every feature of legitimacy and validity. Stop, it had thus attained finality. This was reversed at the said 9th meeting of the council. Full stop. Nothing could have been more unfortunate. Stop. The career of aspiring students has been jeopardized by this action. That's it.
So, like, and there are 4 applications because there are 4 appeals, only same order in all the 4.
Same.
Same, my lord.
It's a common judgment.
So, common judgment, we will file 4 separate applications because there are 4 appeals, my lord. Same order in all the 4 miscases, my lord.
Yes.
My lord.
You, in the beginning, you write, what have you written? No, each of these applications is disposed of by the following order.
My lord.
Then it's
I'll oblige.
Deeply.
the judgment and order dated 8 July 2025 is modified to the above extent only. We direct the registry to carry out this modification in the original order and to issue fresh certified copies accordingly.
I'm so obliged, my lord.
I'll oblige.
Number 7.
This was a fresh matter, my lord. We have taken steps for notice on the respondent. This is the sole respondent, my lord. We have filed affidavit of service, but no one is represented.
Appearing for the first time. Appeal?
He's coming for 3rd time, my lord. On last occasion, notice was not served. Today we have filed an affidavit of service, my lord.
An affidavit of service is on record. None appears for the respondents. We give them a chance to appear.
My lord.
List this appeal and application. What's the difference? 17 September.
Well, I'm deeply.
Number 8 to 22.
Yes, Your Lordship. Lordship, I pray this matter may be adjourned for a day, Lordship.
Sorry?
I pray that this matter may be adjourned for a day, Lordship.
Yes.
My lord.
Because this will take time.
Yes,
so-
my lord.
It will take
Lengthy
some
matter.
time, my lord.
Lengthy matter.
By consent of learned counsel for the parties, this batch of appeals, you tell us a date,
After 1 week.
After 1 week, Lordship.
this batch of appeals may be, is adjourned till 11 September. 11 September.
My lord.
Sitting immediately. Yes, give the papers.
Item number 1 to 5. Pronouncement of judgment.
This court has been shown the score sheets at page 204 onwards of the petition, which appear to have been prepared by 5 officials, which included the director, elementary and mass education, member secretary, DEME, headmaster, lecturer, DIAT, and another official and an official of SDOI EAC. It was sent to A2 for checking and verification. He approved it. That sheet stated that it was prepared on the basis of comparative working sheets. Then I was taken to page 197, which represented the merit list. As an example, learned senior counsel showed me the breakup of marks obtained by the candidate against serial number 6 at page 197 of the merit list, which was equivalent to the computation of score sheet against serial number 30 at page 1205. Then I was shown the final list of candidates at page 194, rated ranking wise. The contents of all the 3 sheets were identical. Now the case of the prosecution is that A1, A2, A3 were in conspiracy, connivance and collaboration with one another, had manipulated the results and thereby displacing the successful candidates and thereby displace the successful candidates by replacing them with candidates of their choice. The original score sheets were different. White ink was used to erase the marks and substitute them by higher or lower marks, as the case may be, to accommodate the preferred candidates and to remove the undesirable ones. Furthermore, the charges that A1, using her influence as minister, had furnished slips to the officers preparing the tabulation sheets indicating alteration of marks. First of all, the three documents showing various levels of allegations. No, first of all, the three documents showing various levels of the computation of results of the selection test had been signed by the self-same five persons. Secondly, the slips which had been produced as evidence would not suggest any specific act of alteration. The originals have not been produced as evidence. These three documents signed by the self-same persons being score sheets at page 204, then the merit list prepared from the score sheet at 197, and the final list in descending order of scores at page so-and-so are identical as narrated by me above. No document showing interpolation or any application of whiting for eraser is on record. The slips which have been produced with some remarks of A1 could be for more than one purpose. It cannot be established beyond reasonable doubt that those slips, those inscriptions in the slips were for the purpose of increasing or decreasing the marks in the score sheet. There is further no evidence to link those slips with the alleged manipulation. Now, applying the principles laid down in the above Supreme Court decisions, a prima facie case had to be made out by the prosecution. If from the prima facie case, the reasonable suspicion of the accused having committed the crime did not arise, the court, on consideration of the available evidence, is empowered to discharge the accused. In this case, the prosecution has failed to establish a prima facie case from where a reasonable suspicion may arise in the prosecution or the court of interpolation of the score sheets. Other documents containing examination results, erasing of marks and substitution thereof by altering marks, the prosecution has hopelessly failed to maintain this prima facie case. Moreover, under section 482, this court has the power to prevent abuse of the process of any court or otherwise to secure the ends of justice. The selection process is of 2008. About 17 years have rolled by. The first FIR was lodged on 18 July 2011. Nothing has moved significantly in prosecuting the accused. Only 29 out of 181 witnesses have been examined. Such enormous delay in prosecuting a criminal case also affects the valuable rights of the accused. The best of their lives are lost by the pendency of a criminal case. Examination of all witnesses at the rate it is proceeding would take up the entirety of the majority of the remaining life of the accused. This kind of protracted prosecution is against the principles in Article 21 read with Article 19 of the Constitution. Therefore, exercising power under 227 of the Code read with 482, especially the part which deals with the power of the court to prevent abuse of the process of any court or secure the ends of justice, I set aside the impugned order dated 23rd August 2022, passed in so-and-so by the learned Special Judge CBI. The charges against the accused 1, 2, 3 framed on 24th, 22 are quashed. The entire criminal proceedings are hereby quashed. The accused are hereby discharged. Criminal petition 36, 37, 70, 71 are allowed. Criminal petition 12 of 2023 is disposed of in terms of this order without passing any order.
I'll oblige.
Ali.
Send this to my chamber.